Okay, so good afternoon. We're here to discuss the implied warranty of habitability today. I will be running through your rights as tenants to have to decent housing, the condition that your house needs to be in under the law, and what you can do to enforce those rights. At the end, there will be a chance for questions and answers. You'll see, because this is a webinar though, on your screen, you should have the option to type questions in the Q&A box, and we will do our best to answer all of those questions at the end of the presentation. So thank you for being with us, and let's get started. So this is part of our Ask a Lawyer program. It's a program we have here at HERA, the Housing and Economic Rights Advocates, in partnership with the Sacramento County Law Library. We have other topics that I'm sure the law library can provide you information on those topics if you're interested in attending other webinars. A little bit about myself. I am an attorney here at HERA, which stands for the Housing and Economic Rights Advocates. We are a nonprofit that provides legal advice and representation to tenants. We provide debt and credit counseling, home preservation counseling, and estate planning. And you can, if you need assistance with any of those areas, feel free to reach out to us. Here's just a disclaimer that we have at the beginning, that this presentation is for informational purposes only and does not create an attorney-client relationship. Just to be clear about that. So let's get started. The implied warranty of habitability, I think the most important thing to talk about first is, what is it? The implied warranty, it's an implied warranty in your residential lease that requires your landlord to keep your residence in a tenantable condition, which basically means that your house needs to be in a condition that's fit for human occupancy. That implied warranty is contained in every single lease in California, whether or not it's actually in there in writing. It's implied in there, and this cannot be waived by you or modified by you, even if you do so in writing. It still applies in full. So where does it come from? It comes from California Civil Code section 1941, which says that your landlord needs to keep your house or your home, your rental property, in a tenantable condition. So I think the next question is, what does that mean? What is a tenantable condition? Well, the next code section, Civil Code section 1941.1, states, well, it enumerates a bunch of conditions that are not acceptable, or the way your house is required to be, that your landlord is required to keep it. So it states that a dwelling shall be deemed untenantable if it substantially lacks any of the following. So if all of these conditions here are not present in, or if any of these conditions are not present in your home, then you have, a implied warranty of habitability problem, and your landlord by law needs to repair that. So first, your home is required to have effective waterproofing of the walls, exterior walls, the roof, the doors, the windows. So if it rains and there's water coming in, your landlord needs to fix that. The plumbing and gas facilities need to be maintained in good working order. You have to have hot and cold running water through appropriate fixtures, and must be connected to an appropriate sewage disposal system. Your heating facilities need to be maintained in good working order. I think it's really important to note that in California, that does not include air conditioning. We do get a lot of calls from people about their broken air conditioning. And unfortunately, by law, your landlord's not required to provide you with working air conditioning in California, unless that's included in the lease, which sometimes it is. The electrical lighting needs to be maintained in good working order, and there needs to be an adequate number of trash receptacles on the property kept in good and clean condition. So continuing with that, the building, the grounds, and the appurtenances need to be clean, sanitary, and free from the accumulation of trash, filth, rubbish, garbage, rodents, and vermin at the commencement of the lease, meaning that the actual unit you're renting needs to be clean when you move in and not have pests. And then the common areas, the community areas that are under the control of the landlord, need to be kept in that condition for the duration of the lease, the entire time that you live there. Floors, stairways, and railings need to be maintained in good repair. And then if you're living in a residential hotel, the landlord must provide a locking separate mailbox for each tenant. Section 1941.1 also incorporates health and safety code sections 17.920.3 and 17.920.10. So what does that mean? Well, those code sections actually list out many more conditions that are required to make your home be considered tenantable under the law. So we'll cover those as well. Under section 17.920.3, if any of these following conditions exist to the extent that it endangers life, limb, health, property, safety, or welfare of the public or occupants, then the home is also not considered tenantable. Your landlord would need to address that because that would be a violation of the implied warranty of habitability. So just to run through these conditions, first is the lack of or improper bathroom, bathtub, or shower, lack of or improper kitchen sink, lack of or improper operation of ventilation equipment, lack or minimum amounts of natural light and ventilation, room and space dimensions less than required by the code, dampness of habitable rooms, the infestation of insects, vermin, or rodents as determined by a health officer or code enforcement, visible mold growth as determined by a health officer or code enforcement, or general dilapidation or improper maintenance. So you can see that's kind of like a catch-all. If there's certain things that aren't listed in these conditions, but they're obviously very bad and not acceptable, they may fall under a general dilapidation or improper maintenance. The lack of connection to required sewage disposal system, lack of garbage storage or removal facilities, the deteriorated or inadequate foundation, defective or deteriorated floor or floor supports, or floors that can't safely support the imposed loads, walls or wall supports that split, lean, list, or buckle, or that can't safely support the imposed loads. The ceilings, the roofs, their supports, if they sag, split, or buckle, or they can't safely support the imposed loads, or if you have a fireplace or a chimney that splits, leans, lists, or buckles, or can't support the load imposed on it, all of those would also be conditions that would violate the warranty of habitability. And then Health and Safety Code section 17.920.10 deals with lead hazards. So if there's lead paint, that's deteriorating, that's creating dust, that's contaminating the soil, or if there is lead, if your landlord's trying to take off the paint and there's lead paint, they need to do that. They need to contain that properly so that lead isn't spread throughout your home. I think it's important to note that lead paint and it's in and of itself is not illegal. However, if any of these other conditions making it basically disturbing it, making it where it could be ingested or inhaled, it does become a warranty of habitability problem. So when you report one of these conditions to your landlord, whether you do that orally or written, they do have a duty to repair that within a reasonable amount of time. There is one exception to that when the landlord does not have a duty to repair, and that is if the tenant is in violation of any of the following obligations, which we will discuss on the next slide, and that tenant's violation of the obligation either substantially contributes to the existence of the dilapidation, or it substantially interferes with the landlord's ability to repair the dilapidation. So let's look at the duties that you have as a tenant that you need to follow in order to avoid this. So you must keep the part of the property that you occupy as clean and sanitary as possible. You must dispose all garbage and other waste in a clean and sanitary manner. Properly use and operate all electrical, gas, and plumbing fixtures and keep them as clean and sanitary as possible. Okay, you cannot permit any person, including yourself, on the property with your permission to willfully or wantonly destroy, deface, damage, or impair or remove any part of the structure or dwelling. So I think that's common sense. You can't, or your friends or your guests can't destroy the property or vandalize it or damage it. And then you must use the portions of the dwelling for their intended purposes. So if you're in violation of any of those obligations, and that's what caused the habitability problem, or if you're in violation of any one of these obligations and that's interfering with your landlord's ability to repair the dilapidations, then at that point the landlord is actually excused by law from having to repair the problem. So it's really important that you're following these. I think most of them are pretty straightforward, to be honest, common sense, but it's good that you know that, and it's important that you're living up to those obligations if you're the tenant. The implied warranty of habitability also includes that the landlord is required to provide proper locks. So that means on exterior doors, there needs to be deadbolts if they're swinging doors, not if they're sliding doors, but they still need to have locks. There needs to be proper locks on the exterior windows, and there needs to be proper locks on any doors for ingress and egress of community areas. It is your responsibility if any of the locks are to notify the landlord if any of the locks are not properly working. Once you've notified them, that's kind of the end of your responsibility, and then the landlord needs to address that. This one may be getting a little bit outdated these days, as house phones kind of become a thing of the past, but under the law, you're still required, the landlord's still required to provide every single dwelling with at least one telephone jack. In a domestic violence situation, if two people are living in the home and one tenant gets a restraining order against the other tenant, then the tenant who is the protected person on the restraining order can ask the landlord to change the locks, as long as they provide the landlord with written proof of the order. And the landlord should change the locks within 24 hours. If the landlord does not change the locks within 24 hours in this situation, then the protected tenant may change the locks themselves. However, it must be a lock of the same or better quality than the original lock. And you must notify the landlord of the change, and then you must provide the landlord with the new key as soon as possible. Also, if the other tenant is excluded from the property due to this court order, this is really important. The landlord is no longer liable to that tenant. If they have a contract saying that person can live in the home, the landlord is excused from giving that person a place to live. But even more importantly, the person who's been excluded by court order is actually still liable to the landlord for rent. So that means if you're in this type of situation, you're living in the home, you have gotten a restraining order against the former other tenant. If you can't pay rent, legally that person, who even though they can't live there anymore, is still obligated to pay rent. So California Civil Code section 1942. We're going to talk about what you can do if if you're experiencing habitability issues in your apartment. So if a landlord fails to repair the habitability issues within a reasonable amount of time after written or oral notice, then the tenant has a few options. One option is to repair and deduct, which basically means you've notified your landlord, they haven't fixed the issue within 30 days. You can now hire somebody, or if you know how to do it yourself, fix the problem yourself, and then deduct the amount that costed you from the next month's rent. Or the other thing is, if the landlord hasn't addressed the issues within a reasonable amount of time, you can actually vacate the property and be released from the lease and no longer be liable for rent. Well, these are very strong options that can be useful at times. We have had some cases where we've used them, particularly vacating the premises. However, there are problems with these options. Now, one problem is that the reasonableness standard, the reasonable amount of time that the landlord has to repair, while 30 days is presumed to be reasonable, that's just a presumption. So if you do these, you use one of these options, the landlord could still argue that if you ever ended up in court, that you didn't give them a reasonable amount of time to address the issue, that you resorted to one of these options too quickly, and you could end up in a legal pickle technically. Is it likely that would happen? It's hard to say, but it's something to keep in mind. And then because of that, let's say it's particularly if you move out, the landlord may still try to come after you for unpaid rent, or try to keep your security deposit. You may end up in a legal fight for that. So these options are available to you. I think that before you exercise either of them, you should probably seek legal counsel. You can call Hara for that, and we can advise you. But just to keep in mind, they are not 100% safe options that are available. So what other options do you have? So section 1942, which we just discussed, okay, first requires that the landlord have notice of the habitability issue. So we recommend always that you notify your landlord in writing. Under the law, oral or verbal notice is sufficient. However, then the landlord could always deny that you did that. So doing it in writing just kind of gives you that paper trail that you made the complaint. So if you notify the landlord of the problem and they don't take action, but you don't want to use those other options we just talked about, repair and deduct or move out, because of the problems I was explaining. Here's some other options that you have. You could call the local health department or local code enforcement and ask for an inspection. Health department, you want to use more for mold, infestations of insects and things like that. And then code enforcement more for structural defects, things like that. But usually, in my experience, most of the time, if you call your local health department or code enforcement, they come out to the home pretty quickly. And my experience also, they will usually, if you're correct about it, about the condition not being allowed, they will issue a citation to your landlord, usually giving them 35 days to correct the issue. And if the landlord does not correct the issue, after that time, they start accruing fees and fines every single day that they're late. So it's actually a very effective method. A lot of the time, most of the time, better than repair and deduct or just moving out. You could also sue your landlord in small claims. You want to make sure that you have proof of the condition, so pictures or whatever the condition is, a video, and then proof of your demand to the landlord to repair, which is also why it's important that you make the report in writing. But small claims court is generally a good option because attorneys aren't allowed. Landlord won't be represented. You can represent yourself against them, and it moves pretty quickly. Small claims court compared to civil court, which can take years for a case to come to conclusion. And small claims court usually is done within a matter of months. The drawback, of course, is that in small claims court you can't ask for more than $10,000. And then if you have very, very serious habitability issues, where you just feel like small claims court is just not going to be good enough, you can also seek out private attorneys and see if they'll take the case on a contingency basis, which is basically where you hire the attorney and you don't put any money up front. They represent you, and then if you recover money they take a percentage of that at the end. So here's some restrictions on the landlord. If you have, like we talked about, made a complaint to either the local code enforcement or health department, and they have issued your landlord a citation, basically saying, look, this home violates the warranty of habitability under section 1941.1, then your landlord doesn't fix the condition within the 35 days required by the citation. And of course, as we talked about earlier, you didn't cause the habitability issue. At that point, after the 35 days is up, your landlord cannot, by law, demand rent from you. They can't collect rent from you. They can't increase your rent or issue a 3-day notice to pay or quit until they actually fix the condition. And if they try to do that, penalties include actual damages of $100 to $5,000 and attorney's fees, which attorney's fees are helpful too, because it will make it easier for you to find a private attorney who would take your case. Also, this is really important. This comes up a lot in our work at HERA under Civil Code section 1942.5. It's if you make a habitability complaint, it's illegal for your landlord to retaliate against you after you do that for 180 days. So that includes just either if you just tell them orally or written, if you notify them of a bed bug infestation, if you make a complaint to appropriate agency, like we were just talking about, after the inspection or citation by the agency, if you take them to small claims court or civil court, or if you take them to, if you win in court either, but even filing the case, you're protected. So that's 180-day protection. Let's look at what actually constitutes illegal retaliation by the landlord. That means they cannot attempt to evict you for 180 days from the property, unless the only exception to that is if for unpaid rent. But they can't increase your rent. They can't decrease any of your services. So if your internet or something is included, or you have a parking space, they can't take your parking space away or take your internet away because you made a complaint about habitability. They can't report people. They can't report you or people associated with you to immigration authorities, or threaten to do any of the above. If they do any of those things or threaten to do them, that is illegal retaliation. And those protections also cannot be waived by the lease. If your landlord does retaliate against you, they can be held liable for actual damages plus punitive damages between $100 and $2,000 for each time they do it, if they act with fraud, oppression, or malice, and attorney's fees. Your landlord's also, this is important, prohibited from harassing you. So under Civil Code section 1940.2, the landlord cannot do any of the following with the intent of influencing you to move out. Violate Penal Code section 484, which is fraud. Violate Penal Code section 518, which is extortion or blackmail. They can't use or threaten to use force, willful threats, or menacing conduct that interferes with your right to quiet enjoyment of the premises that would create an apprehension of harm in a reasonable person. They cannot commit significant and intentional violations of section 1954, which requires a landlord to enter during normal business hours, requires them to give you 24 hours prior notice before entering, and it limits the reasons that they're allowed to enter your unit to just very few situations. So that basically means if they're abusing that right, that could be considered harassment. And then threatening to disclose information about the immigration status of a tenant, occupant, or other person known to be associated with the tenant is also illegal harassment by a landlord. If you can prove in court that you were illegally harassed by your landlord, you're entitled to up to $2,000 for each violation. Excluded from this harassment statute or good faith written or oral warnings given to the tenant regarding conduct that violates or may violate the lease rules, regulations, or the law. That's not considered harassment, or an oral or written explanation of the lease rules, regulations, or laws given during normal business hours. That's also not considered harassment. So tips for you if you find yourself in this situation. I think we've covered some of it, but let's go over it because it's important. You want to create a paper trail. So that means notifying the landlord in writing. Email is good, written letter is better, but either way, make sure you save a copy for your records. If your landlord responds in writing, or if they give you anything in writing, whether that's the notice on your door, an email, a text message, you want to make sure you save that stuff too. And then, of course, the condition that you're addressing, make sure you take pictures and keep them, adequately document the issue. Maybe times where a video is better, but I would always take still shots too, and make sure you save the evidence. And then when you're doing this, whether you're taking the pictures or you're communicating with your landlord, remember this, that you may end up presenting this to a judge someday. So keep your communications and your tone appropriate. It's not going to feel very good if you give your landlord a letter that's laden with cuss words or insults and things like that, and you have to give it to a judge one day. So keep that in mind when you're communicating, writing with the landlord. That's it is in writing, and you shouldn't put anything in writing that you wouldn't want the judge to see. Additional resources here if you want to talk about this or you have questions. These are the resources. So the Sacramento County Public Library, you can see their information there online, or their reference email. And then if you would like to talk to a lawyer, you can definitely call us at HARA. There's no cost, which I think is surprising to a lot of people. So it's important to say that it doesn't cost you anything if you call us. And you can visit our website. You could send an email here at the address listed, or give us a call, 510-271-8443, extension 300. I'm going to go through the questions and answers now. Please, though, at the end of that, we are going to have a survey for you to take about today's webinar. So we really appreciate if you just kind of stick around and take care of that. You don't want to take a couple minutes. Thank you. So let's see what we can, the questions and answers. Anonymous question: Does this include living conditions and furniture plus the entire apartment covered by termites? Yes, the answer to that question is yes, and I think that would be really a good situation for you to call your local code enforcement and ask for an inspection. And they should, if there is termites, as you explained, they should give a citation to your landlord, which should help you in addressing that issue. Okay, a question from Amina: can my landlord threaten to raise the rent because I complained about plumbing and no running water? No, your landlord cannot do that. That is illegal retaliation. As I explained before, at least for the first 180 days. And I think that even after 180 days, if you could truly tie that threat of a rent increase to your complaint, I actually think it's still technically illegal retaliation. So if you find yourself in that situation, definitely reach out to HARA. We can help you address that. Next question is, what if the landlord says, I created the habitability problem? Well, that's going to be a difficult situation. I think a lot of times it's probably the proof is going to be in the pudding, as they say. It's going to be pretty obvious what created it. I mean, if the house is falling over or there's plumbing issues that aren't something you could have caused or something like that, well, they're not going to have a very good argument that you created the issue. But I think that's why, it's important that you document it. Document your landlord as soon as you notice it, or notice your landlord as soon as you notice the problem, document the problem. In this type of situation, it would probably be useful to call for an inspection from code enforcement or the health department. and hopefully they could kind of back you up that this isn't your fault. But again, if you have these specific questions and you feel like there's going to be some type of legal battle or kind of a pickle coming up, that's when you'd want to contact a lawyer too. Contact Tara. We can help you out with that. I think for a situation like that, it's going to be problem specific or question specific, depending on the issue that your landlord's blaming on you. What would be the best way to handle that? If the landlord has a posting in the building that says notify the office if you have COVID, is that legal? I honestly, I don't know the answer to that question off the top of my head. Seems I haven't been posed that question by anyone else yet. So I don't want to give you bad information. But that's something, if you wanted us to look into that more, you could reach out to Herod. We could set you up with a lawyer, either myself or one of my colleagues, and we could probably dig into that for you. But sorry that I do not have an exact answer for that today. For the landlord entry notice, is there a window time of at least 4 hours instead of 8 hours? I'm not exactly sure what you're trying to get at, but if you're saying like the landlord says, hey, we're coming tomorrow between 9 to 5, and you're saying, well, can we make it between 1 and 5 or something like that? I don't, again, have a definite answer for you on that. However, I've reviewed the statute many times. I don't remember seeing anything in there. It would be helpful that if there was a time when you're available and you could work that out with your landlord, but they are required to give you 24 hours notice. So, technically, if they notice you at 4 o'clock in the afternoon, they can't come at 9 a.m. the next day. But I don't have a 100% specific answer for that. What if the landlord says there's no record of your report? Well, then it's going to be your word against theirs. If you did it orally, which is why we recommend doing it in writing. If you write them a letter, you send them an email, him or her, it's going to be hard for them to say there's no record. I mean, they might not have a record of it, but it existed, and it's not your problem that they didn't keep proper records. So that's why it's very important to make these complaints in writing. Okay, May rent was increased. My rent was increased in April, and it was improperly served to me. I brought it to the landlord's attention, and my rent was still increased. That's something you should call Hara. We can help you address that. It is true that if you were improperly served with a rental increase notice and it's not valid, we can help you address that with your landlord. If the landlord is friends with a neighbor who you are having problems with and harasses us unnecessarily, we have had police show up for noise complaint, and they've stood by our door for 30 minutes without us knowing and didn't hear anything outside of normal noise. This has happened 3 to 4 times. Okay. Well, I'm not sure if you're saying that the noise complaint was made by you or against you, but that's a different topic from today's presentation, but you do have the right to quiet use and enjoyment. It's also implied in every lease in California, just like the implied warranty of habitability, which basically means you have the right to use and enjoy your rental unit free of substantial interference by the landlord or other tenants of the same landlord. So I think what you're describing here probably does constitute a violation of the the right to quiet use and enjoyment, but I need to know more specific facts about everything. But generally, if it's interfering substantially with your ability to enjoy and quiet use of your unit, then it's probably not legal. And that's something else you could call Hara, and we can set you up with someone for that. I have spots growing in my living room and bedroom. I've talked to them, nothing has come about change. So I'm guessing maybe you're referring to mold there. That would be definitely something you want to call the health department about. Your local health department, they should come out pretty quickly. If there's visible mold, that's what they're looking for. They will issue a citation to your landlord and tell them they need to address that right away. I think that's let me see. I think that's all of the questions. If there's not any more, I guess we can conclude the presentation. Thank you so much for coming today. We really appreciate it. We hope that it was helpful, that you actually got something out of it. And please, if you don't mind, stick around. You can see in the chat box, there's a link to the survey. So we'd really appreciate it if you could, you know, take the survey for us. And it looks like we had just one more question pop in. So I asked the landlord to put a new garbage disposal, but they just keep, I guess, fixing the same. That's a tough one. I mean, if they're really fixing it within a reasonable time, that's tough. If it keeps breaking, that's some specific. I would need to know more facts again, but you could reach out to Hera and we can help you address that if need be. All right, it looks like all the questions have been answered. Again, thank you very much for coming today. We hope it was helpful. Please take a few minutes to take the survey, and that's it. Thank you.